Hello, everyone. So, as was kind of mentioned, this was put together by the Young Lawyers Division, a subcommittee of the Diversity Committee. And this was a subcommittee of the YLD that was formed by a friend of mine, Abai, in 2014, I think. And kind of the general goal of the subcommittee was to just encourage diversity among the young lawyers and kind of figure out ways that we could increase retention of diverse lawyers in Iowa, and just kind of whatever fun projects we could think of. And this was one of the first ones that we did. And so what we did was we solicited anecdotes from the Iowa bar regarding just kind of inappropriate stories of things that had happened. And it kind of came about because it was kind of our friend group getting together, people that Abai had recruited to be on this committee. And we would just kind of tell stories of, hey, we're 1 or 2 years out of law school, and here are some things that people said at work, and can you believe they said this? Is just so funny. Can you believe it? And everybody had these stories, especially the women. And so we thought, well, it'd be kind of fun to get some more stories from a broader audience and do some presentations so that, you know, it's not just some girlfriends sitting at home kind of complaining about things that happen at work, and people can kind of get some more insight into how people interact with young lawyers in particular, and just different diverse groups in the Iowa bar. So this presentation covers background demographics of the Iowa bar and national bar, and then the ethics rules that apply to this type of thing, and then the bulk of it is anecdotes that we collected. So demographics, age-wise, Iowa skews much older than the national bar, and the statistics from the national bar are from 2012. That's the last year I think that they have updated these, but the Iowa bar statistics are from this year, so these are accurate. And you can see here nearly 50% of Iowa's bar is 55 years or older, and it's kind of crazy that over 25% are 65 or older. Maybe some of these people aren't actively practicing, but they are members of the bar. And nationwide, there are fewer attorneys that fall in those older age brackets, but here in Iowa we definitely skew much older, and I think that's an issue that people are generally familiar with in terms of just rural representation and, you know, all the other attendant issues that go with that. Race-wise, in Iowa, and for these statistics, again, they're from 2017 from the Iowa bar, and there are a lot of people who didn't answer their race, so 40%. And the statistics on this slide just represent the people who did answer their race on the bar's survey. But of the people who did answer, 96% are Caucasian. And when you compare that to the statistics just in Iowa as a whole, Iowa is 91% Caucasian. So the bar skews even further white than the Iowa population and the national population. So we've got pretty low numbers across the board for Hispanics, African Americans, Asians, Native Americans. And for all of these groups, the representation of the Iowa bar is lower than the representation in Iowa. So for instance, Hispanics in Iowa are 5.8% of the population. For the Iowa bar, it's only 1.2%. So, and that's true for all of those categories. For sex, Iowa's bar is 30% female and 70% male. Guess what? The Iowa statistics are 50-50. So we skew more male, and even a little bit more male than the national average for lawyers. So 65% of all lawyers in the United States are male. Iowa is up to 70. I think some kind of related statistics that are interesting on sex is that women have composed more than 40% of law school classes since 1985. So even though we've had a lot of women entering the pipeline through law school, we still are below that in terms of the average across the bar. Oh, and one thing I was gonna see, does anybody have a guess on how many lawyers there are in Iowa?
8,000.
That's pretty close. From the bar gave me numbers that were 7,937, and I saw something on the ABA's website that said we had 7,500. So somewhere in that range, but yes, good guess. But back to sex, we've we still have not kind of reached that level, even though it's been 40% of women in law school for a long time. We're still underneath that in terms of our statewide averages. And I think another interesting statistic is the fact that nationally, 87% of paralegals are female. So it's just the way the legal profession is structured. We have a lot of older men and just hierarchies within firms and in law offices where we have a lot of older men and females working as younger staffers or paralegals and office staff. Now on to the rules. I know Judge Scieszinski will probably talk about these some too, so I'll go light, but here are the main rules that apply to the topic today. Iowa Rule of Professional Conduct 32.8.4 says it's professional misconduct for a lawyer to engage in sexual harassment or other unlawful discrimination in the practice of law or knowingly permit staff or agents subjects to the lawyer's direction and control to do so. So we as lawyers have a duty for ourselves and to prevent other people from doing things that would violate this rule. And just kind of more generally, we always talk about professional courtesy and integrity, and those equally apply to all these things. Some of these stories will kind of be more harassing or discriminatory, and some are just in poor taste. And so those still kind of fall, I think, within our professional rules as far as professional courtesy. And in the ethical context, the Iowa Supreme Court has defined sexual harassment very broadly. There's a 2015 case, Iowa Supreme Court Attorney Disciplinary Board v. Moothart, where we talked about sexual harassment. And that case involved sexual conduct between an attorney and a client. But in that case, the Supreme Court defined sexual harassment as any physical or verbal act of a sexual nature that has no legitimate place in a legal setting. So that could be any kind of sexual joke even. The court hasn't ruled on a case where it's kind of been more on the outskirts of sexual behavior or joking or non-touching. But, you know, if you look just at that definition, those types of comments would fall within that. And in the Moothart case, the court also recognized that they define that really broadly, and that compared to civil cases involving sexual harassment, when looking at the ethical context, the court isn't going to require harassment to be ongoing or pervasive. So even just one remark could maybe get you in ethical trouble. And they've also rejected the notion that consent is a defense, specifically with attorney-client relationships. So maybe in future years, we'll kind of get that defined more and where the bounds of that are. But right now, it seems like the bounds are kind of a no tolerance, a zero tolerance policy. For judicial conduct, it's kind of the same thing, although more categories are included in the judicial rule. Like there's not supposed to be discrimination based on marital status or political affiliation. And judges are also have a duty to prevent court staff as well as attorneys from engaging in discriminatory behavior. And I like there's an example of manifestations of bias or prejudice that's in the comments to the judicial rules. And I think these capture a broader range of what we don't want to happen. So it includes epithets, slurs, demeaning nicknames, negative stereotyping, attempted humor based on stereotypes, threatening, intimidating, or hostile acts, suggestions of connections between race, ethnicity, or nationality and crime, insensitive statements about crimes against women, and irrelevant references to personal characteristics. I think that's a nice list that captures just anything that's in poor taste, really. It's going to make somebody feel disrespected or unwelcome in a proceeding. Now on to the anecdotes. Oops. So as I mentioned, these were kind of started between our conversations with friends, and then we sent out a solicitation to various groups in the Iowa bar in 2014. The anecdotes we collected tend to be skewed towards female or just kind of sexual comments because that's the largest group in Iowa that's probably going to receive inappropriate comments, and because we sent this out through the Polk County Women Attorneys and the Iowa Women Attorneys Organization. So those were a lot of the responses that we got. We got 37 in total, and they span all people were supposed to tell us when this happened to them. And so some of them are maybe from 5 years before, and some of them are more current. But we just kind of like that this puts more of a face and some color to how people feel, you know, what they're going through and how it impacts them and kind of how they perceive comments that are made to them. And, you know, with everything that's been happening this year with the Hollywood stories, they're just kind of interesting to read because you think, what the heck's going on? So these are kind of our version of that, although we were 2 years ahead of the big breaking news this year. So we sent out this survey and we asked for stories of insensitive workplace comments regarding gender, age, pregnancy, race, color, sexual orientation, gender identity, religion, national origin, or disability. And we also asked for stories where individuals demonstrated extraordinary sensitivity in response to an insensitive moment. Because we were also trying to look for teachable moments or just how people could react when they heard something like this. Because a lot of the things are, you know, jokes or something that may seem more innocuous, and so it's harder to figure out how you should respond when it's nothing that just slaps you in the face. And I was also just mentioning, I know the ISBA Federal Practice Committee recently did a survey just on gender discrimination this fall, and I think they were also soliciting anecdotes, so I'm sure we'll kind of have an updated presentation from them sometime in the future. I did a master's degree in sociology when I was going through law school, and it was a lot of the research in sociology at that time was about implicit bias, and it's been interesting because it was kind of around the time I graduated law school and got that master's degree and came to the bar. I was working for Justice Waterman at the time. This Pippin case was before the Iowa Supreme Court, and there were all these issues of implicit bias. So I was like kind of going out of school, and these were kind of really new issues coming before the court. And I think the Iowa Supreme Court has kind of been more on the front end of recognizing bias, and we've done a lot of trainings with the judicial branch on bias. And so Justice Waterman and Pippin talked about what implicit bias is versus explicit bias. And explicit is more the deliberate, malicious type actions and comments. And implicit bias is something that just pervades decision-making because it has to do with your assumptions that you make and the shortcuts you make in your brain. You know this one person acted this way, and here's another person that looks like that person, so I'm gonna assume they're gonna act the same way. And again, in this 2017 case of State v. Plain, that's another case where the court was dealing with implicit bias and how we should talk about it in criminal jury instructions. So the court has continued to recognize implicit bias, and I know Judge Scieszinski is going to talk more about this and kind of break down examples of how implicit bias acts and how it influences people's actions at work. Because that's what a lot of these stories are, is just things that maybe the person saying them doesn't even realize that they're wrong. But when you think about it, what they're saying is based on some assumption that is offensive to that person because it doesn't apply to them. And so as we go through these anecdotes, I would encourage you all to think about your initial reaction. Do you think the comment was funny? Do you think it was obviously inappropriate? Does it make you cringe? Or you just kind of think, not a big deal? Because each of these stories, for the person to have filled out our survey and responded and said this thing, it must have stuck in their mind as something that kind of bothered them or made them feel uncomfortable. So I think a lot of these, maybe we wouldn't feel the same way as the person who heard them, but you kind of have to put yourself in the other person's shoes and think about that. And I think as you recognize, oh, my reaction is different, you kind of start to realize the assumptions you have maybe are different from some other person's and how that would come to bear on the situation. And we kind of organized these slides as things that we thought were more obviously inappropriate, and then kind of getting into the more implicit bias assumption type stories. But for race-based, our first story here, a person wrote, "I work in a small rural town in Iowa. At an office meeting, a non-attorney staff member was describing an experience they had many years ago in a Midwestern city and referred to the area as a black slum. The individual detailed feeling uncomfortable and unsafe due to their pale clothing and skin tone in their clothing. The story dragged on for several minutes and included derogatory names. It was told in front of the entire office, and one of the attorneys, who has a darker skin tone, became visibly upset, and eventually asked to leave the meeting. Everyone was uncomfortable, but no one said anything, not even the senior partner. I was disappointed in myself for not being able to jump in, but also disappointed in the senior leadership for not addressing the incident during or after the meeting. Which I think is a common theme with these, that people don't know how to deal with them, and so it just kind of passes by, and everyone is kind of uncomfortable, but nobody acknowledges it. So here are some gender-based stories that are more overt things. There is a partner at the firm where I work who always has and still does look at my breasts when I talk to him. He has done this every time I have ever had to speak with him, which doesn't happen all that often, and thank goodness for that, because it is very uncomfortable. I'm not the only female in the firm to whom this happens. When I started 8 years ago, I mentioned it to others, and they confirmed that's just the way it is. Another one where it just gets kind of swept under the rug, even though a lot of people are probably uncomfortable with it. A second story. I'm a young female attorney. An older male attorney from my office called me out to his administrative assistant's desk one day upon receiving a gift basket from a client. The gift basket contained a variety of fruits, meats, and cheeses, your typical holiday gift basket. I walked out to his administrative assistant's cubicle. The male attorney picked up a large summer sausage from a gift basket and, in front of several administrative assistants, said to me, "Here, this looks about your size." Third story. I am a female attorney. Relatively early in my practice, 1996 to 99, I was working opposite a much more experienced male attorney. We were involved in a contentious dissolution. Opposing counsel had not provided me with the documents requested in discovery, despite the court's family law requirements order, an informal request, a good faith letter, and a call to his office. I finally filed an application for rule to show cause, and when he got the order setting hearing, he called to express his shock and frustration. When I picked up the call, his question to me was, "What is your deal? Are you on the rag or something?" Number 4, a few years ago, I had to attend a deposition in which I was deposing one of the parties. When I arrived at the location for the deposition, the deponent's attorney started asking questions about a scheduling conflict. He was a man in his mid-50s to 60s. The questions were meant to attack my integrity and honesty about the scheduling conflict. He had raised his voice and was turning red. He did this in front of counsel for the other party, the deponent, and the court reporter. I told him I didn't appreciate him verbally assaulting me, to which he responded, "Don't talk to me like that, young lady," as though I was a small child or his daughter. It was quite embarrassing and demeaning to be talked to like that in front of the deponent and the court reporter, as well as the other counsel. I felt he would not have treated a male attorney similarly. A fifth, this happened in approximately 2010 to 2011. During a recruiting committee meeting at my firm, a young male partner was recounting a tale of him getting beaten out for a clerkship by a female candidate. He referred to the successful female candidate as that bitch. Number 6. When I was a young attorney, I was invited to attend a large meeting with my boss and many members of management of a large company. Everyone in the room of about 20 people was male except me. The person conducting the meeting turned to me and asked cheerfully if I would mind taking the minutes. I was embarrassed but politely agreed. Number 7. This is one that actually is one of my stories. This was when I was maybe 2 years out, and I was trying a murder case with Alfredo Parrish, and the county attorney, who was maybe 10 years older than me, the assistant county attorney, repeatedly referred to me as little lady, which I think was just, supposed to just kind of irritate me, which it did, but, I didn't do anything about it either. Okay, some more. Number 7. As a young, newly married female attorney in 1992, I was working for a male attorney in his mid-60s, and my husband traveled quite a bit. When my face broke out in blemishes one day, my boss offered his unsolicited advice that it was because my husband was out of town too much and I was not getting enough sex. I was floored and tried to laugh it off, but I got another job immediately. So that's an instance where it went unaddressed and they just lost an employee over it. Number 8, while a law student, I met and started dating my boyfriend, now fiance. While I was discussing the weather with a judge I had just met, he asked me if I played golf because it is a good place to pick up men. Number 9, I am a young female attorney and have had many older male attorneys attempt to give me hugs or squeeze my shoulder upon being introduced, as opposed to using handshakes. I find this inappropriate and unwelcome. It would be different, perhaps, if we were old friends, but many times it happens on an introduction. I've started carrying a rather large shoulder bag for my laptop and case materials to discourage such conduct. I think this is something probably a lot of young females deal with because people just tend to be more familiar with women. I know I have clients that hug me, and I don't think that they would hug a male attorney, and it's just something you kind of have to be aware of and be ready to deal with. Be prepared that somebody might come in for a hug and you have to get your hand out first or something like that. Number 10. As a law clerk around 2010, I attended my firm's holiday party. I was the only female law clerk at the time and was groped by a male partner at the party. It put me in a very uncomfortable position because I knew he was on the hiring committee and I was going to be vying for an associate position. I knew the male law clerks didn't get groped and therefore wouldn't be making a complaint about it. I ended up not saying anything because I thought it would jeopardize my chances of getting hired. Number 11. This happened to me in about 2007 when I was a young female associate. I went to lunch with a group of male partners and we sat on a patio. It was a sunny day and I positioned myself so as to soak up the sun. The most senior male partner said, "Feel free to take your shirt off." I made a shocked, disgusted face. The youngest male partner shook his head and put his head in his hands, but no one said anything, they just uncomfortably laughed. Anybody have any thoughts about those? That finishes off the slide of obvious gender things. And I know that when Judge Scieszinski talks, she's gonna have some opportunity for discussion too, so hopefully these kind of are percolating in your mind and something might jump out for you in her discussion too. Here are some race-based assumptions. I worked for an advocacy organization that focuses on individuals' rights as a staff attorney in 2013. In a discussion with a group of attorneys, there was a reference to Drake University being lily white, made by a white male lawyer. I did not comment. After the meeting ended, my white female supervisor chastised me for failing to stand up because I, as an African-American female, should have been offended by his comment. I explained that I did not take the comment as racially insensitive or derogatory. My supervisor then countered that in the future she expects me, because apparently I'm the voice of the Black community, to stand up and say something in opposition to comments such as his. Although I was not offended by the original comment, I was very much offended by my supervisor's comments. Although I hope they were well-intentioned, she had placed me in an extremely uncomfortable position and had essentially questioned my Blackness and commitment to equal rights. Here's one on sexual identity. As a law clerk around 2010, I was asked by a male heterosexual partner at my firm if I wanted to work on a case involving sexual orientation discrimination. The partner thought I might be gay and would therefore enjoy being involved in the case. I'm female and heterosexual, and I still enjoyed working on the case. Here we get into more gender-based assumptions as opposed to the kind of more obvious things, or what we hope were obvious at the beginning. I, a female, was prosecuting an individual who interfered with a police officer during a domestic disagreement. While finding the male defendant guilty, the magistrate judge, also a male, said that none of this should have happened, as the female in the dispute should have known better since women know how to push men's buttons. In the mid-'80s, my partner and I, both women, had a small firm specializing in appellate practice. Other attorneys, primarily small firm and solo practice trial attorneys, hired us to do their appeals. Most of them were great to work with. However, I met with one attorney who had hired us to do his appeal. I told him after doing initial research that I did not think there were any grounds for appeal. His response was, "You're a lawyerette, you'll think of something." We ended up writing a brief for him based on his ideas, and he lost on appeal. We also charged him double our normal hourly rate for the lawyerette remark. Number 3. This happened years ago, but when I was pregnant with my first child, an older partner in his 70s came into my office and made some comment about me being a princess in a demeaning and derogatory manner. I became upset, told him I never acted like a princess, came to work every day, and did my job to the best of my ability all day, every day. But after he left my office, I did cry and ended up leaving for the rest of the afternoon. So, sometimes can make people feel pretty bad. Number 4, my attorney boss asked me who my work spouse was. He also told me that there would be no procreating at the office holiday party and deemed me to be melodramatic. Number 5, I watched a final round for mock trial. During the comments period at the end, one male volunteer mock trial judge berated the only female on a team for wearing beige nail polish, which I couldn't see from 10 feet away. He noted that some people find it unprofessional and distracting for women to participate, so it is important to tone it down. The female student was wearing a modest, dark-colored skirt suit and minimal professional makeup. Even though many lawyers told her afterwards that they thought the comments were inappropriate, her team lost the round based on that judge's scores. And that's another example of how it just kind of takes one person, whether it's in a firm or anything where you have somebody on a hiring committee. If you have just one person who kind of has these bad views, they can throw the whole thing out of whack. I am a female lawyer who joined a firm a year ago straight out of law school. A male lawyer with several years' experience recently joined the firm. He set up weekly meetings with me to discuss business issues because, in his experience, young women do not understand business matters. I managed a sales company for 2 years before going to law school and took it from $750,000 in sales per year to over $1 million in sales per year. I don't know everything about business, but being singled out based on gender and told things I already know is frustrating. I don't feel comfortable reminding him of my background, and I am hopeful we will work together on a case soon, so I may demonstrate that I do understand business basics, even though I'm a woman. We kind of categorize these separately because there were several of them that had to do with family planning decisions or just babysitting. We put this one in there. So a male partner asked me, a young female associate, if I would babysit his children. I also got similar requests before I became a lawyer, but when I was out of undergraduate, I think that must be common. Number 2, when I, a young female, was being interviewed for an associate attorney position by a senior partner who was an older male in his late 50s, early 60s, the partner asked if there was anything about myself that he should know. He said, for example, one time we hired someone and found out a couple weeks later that she was pregnant. Anything like that? This happened in 2005. Before moving back to Iowa, I worked as an associate at a firm in another state. One day I went to tell my male mentor in his 60s that I'd be taking a couple days off to go back to Iowa to visit my brother and sister-in-law, who just had a new baby. Instead of saying congratulations or something similar, the partner said, "Oh, how old is your sister-in-law?" I said, "I think she's 32. He said, "Oh my, she better get going then." I awkwardly ended the conversation and left the room, being a woman of over 30 myself. Number 4, in 2014, I wanted to travel to attend an important meeting. The trip would have been on the heels of another lengthy trip, but I felt it was key to my career to attend. When I told this to my attorney boss, he responded, "Are you sure you want to leave your husband and son again?" Number 5, when I left a law firm to go in-house, a partner for whom I had worked endless hours responded to the news by saying, "So you want to start a family?" Number 6, in 2014-15, my male partner boss in his 50s called me, a female associate in her late 20s, into his office one day to talk about a client. Having gone off on a tangent, he then said, "You will face challenges being a woman, and I know that. I hired you knowing full well that you would walk into my office someday and tell me that you're pregnant." It was downhill from there. This conversation bothers me for a few reasons. It told me that he not only assumes I'll have children just because I'm a woman, that I'll make the decision to stay home with them, but also that I'll make the decision to stay home with them. It also bothered me that he acted like he should have been commended for hiring me despite my having a uterus. Anything to add on those? Anybody have a story they want to chime in? No. This was just kind of a catch-all we had. This story is from late 2014. Female coworkers were having a discussion. One is a baby boomer in her early 50s, and the other is a millennial who is about 30. The boomer started complaining to the millennial about how millennials are entitled brats and think they are the generation of participation trophies. She said her own millennial children think they can jump up the rungs at work without putting in the time and hard work to move up. Excuse me. She generalized that all millennials are like this without taking any responsibility for her children's attitudes and behaviors. She didn't seem to realize that the coworker self-identified as a millennial also. Oh, I'm struggling. I had a little bit of a cold this week. Since everyone in the office was also a boomer, the millennial did not feel comfortable pointing out the generation's positive traits, feeling it would have involved bringing their age into the discussion. Oh man. This one has to do with the religious background. So this one is a minority associate who's a Hindu is meeting with a partner. The partner begins discussing how to get business. The partner says that he sometimes will get business when he is at church, and then turns to the associate and says, kind of like if you were at a mosque. The partner didn't realize that mosques are where Muslims go to pray, not Hindus. It's just a kind of basic lack of information one where somebody made an assumption that was wrong. Number 3, while interviewing for summer private practice clerkships during law school, potential employees repeatedly would notice I attended college in Utah and without fail would ask, I see you went to school in Utah, so are you Mormon? Number 4, at the close of our law firm's holiday party, one partner wished everyone happy holidays, saying things like Merry Christmas and the like. And then looking at the minority who is a non-Christian associate, the partner said from across the room, and whatever you are. So here we have the Iowa not so nice category. This is, like I said at the beginning, the professional rules of conduct that have to do with civility and respect. And these are just kind of comments made in poor taste that don't really fit with the standards we hold ourselves to. Number 1, probably about 20 years ago, a senior attorney was giving some welcoming remarks at a meet and greet session involving firm attorneys and representatives of a major client. And there was one female attorney present. The senior attorney, a male, signaled an intent to tell an off-color joke by suggesting that women might want to leave the room. Here's a similar story. I attended a firm event at a firm shareholder's residence. I was the only female attorney to attend. The male attorneys were all making crude and crass jokes, mainly with regard to females. After likely not being able to mask my feelings towards such jokes, I was told that I was free to leave whenever I wanted. Number 3, while at work in my 8th month of pregnancy, I was told that I must be having a boy because I was carrying most of the pregnancy weight in my ass. Number 4, my office throws a small birthday party, a cake or lunch for the team for each attorney and staff member's birthday. I am a second-year attorney in my late 20s. Last year on my birthday, I was asked whether I was turning 12 and whether my fiance, who is 2 years older than I am, was going to go to jail. Number 5, I worked for a lawyer who repeatedly complimented my attire and commented on other individuals' weight issues, clients, judges, etc. I understand being concerned for others' health, but the descriptions of women were particularly colorful and derogatory. So as I mentioned at the beginning, we also asked for stories about maybe where somebody had spoken up and something positive had come from it. And so we do have a few of those, which is nice. So one of the stories earlier was about someone on the recruiting committee who had referred to someone else as that bitch. And the end of that story is as follows. An even younger female associate spoke up saying something to the effect of, oh, because she's a woman, she's a bitch, that's offensive. And the male partner stammered and stuttered. The incident was then reported to firm management and the firm removed him from the recruiting committee. So I'm sure that was a little uncomfortable for the associate to confront the male partner like that, but it did lead to something positive. Another one was the story about how a partner said, Merry Christmas and whatever you are. And that one ended up, the partner, I think later, just on his own, realized that had been an insensitive thing to say and emailed the associate and asked to meet and apologized profusely. This has to do with the one where the woman was asked to take minutes at a meeting because she was the only woman there. Afterwards, she spoke to the gentleman privately and shared her view about how awkward the request was. The color drained from his face and he apologized. At every meeting thereafter, he announced that we would take our own minutes. This man then became my champion and was directly responsible for other recognition I received for my work. Although my boss, a third party, had been outraged at the initial meeting and thought I should have forcibly and publicly rebuked the request, by handling the issue privately, I saved the inadvertent offender embarrassment and came out ahead. I think that's kind of the model that everybody would hope would happen, but I think it takes a lot of kind of courage to confront somebody about things like that. I kind of had a similar situation where someone kind of got a little handsy with me, and I later talked to them about it, and they apologized profusely. But even when you do have those kind of conversations, it's hard to be honest and really frank with, you know, how the power dynamic works and why it was so uncomfortable. So even in the situations where it's really good, it's still really hard to have those kind of conversations. And in preparing to give this presentation today, I had asked my friends, hey, does anybody have any news stories lately? And I didn't get any responses, so maybe people are getting better. And they kind of said, well, maybe it's because we've been in practice a few years and people get to know you and, you know, get to know your threshold for jokes and get to know that, hey, you're not kind of on the market to be dating or something like that, and you just don't get as many things that are kind of pushing the limits. But I thought that was positive, and hopefully with everything that's coming out this year in terms of just publicizing inappropriate comments, it'll get a lot better too. So that's all the anecdotes I have. Does anybody have anything to discuss with those? Anything similar? Yes?
You mentioned the intervention where the offender ultimately became the champion.
Mm-hmm.
And I was wondering if you had any observations about the importance of bystanders or offenders who realize the error of their ways taking on the mantle of becoming the champion.
I guess I don't have there weren't any stories that we specifically collected about that. Kind of makes me think of is just how I think a lot of these things stories we hear about people are comments made out of ignorance. And so if nobody speaks up, the person just keeps saying dumb things to other people and making more people feel uncomfortable. I think a lot of these people probably like these successful interactions or interventions, you know, like a conversation I had with someone, it did lead to, I'm sure, that person behaving much different in the future just because they were more aware of the fact that it was perceived to be really inappropriate and they hadn't realized it before. Mm-hmm. Anybody else?
I think part of it is early in your career, you talked a little bit about the power dynamic, and it's really the total imbalance of power, or at least perceived imbalance of power. And so it's very difficult to say something, or especially to come up with an appropriate response in the moment. I know that happened to me early in my career, and then later on, you think of what you wish you would have said. Mm-hmm. But I think, hopefully, as more women are continuing in the profession, and as that number increases from the 30% up to the 40% level, current law students, then more women will be comfortable, speaking out and responding, or that balance of power will change enough that there are more women in power who will be able to speak up and respond to those inappropriate comments in the moment, or at least privately afterwards, and try to be what we call the bias interrupters.
Right, and that's kind of what we wanted to do with getting these anecdotes, was just normalize, that these things happen and that there are ways you can respond, and it's totally appropriate, and you can do it, and here are some ways. And I think that it is tough because of the power disparities, especially with higher level partners that are maybe male and lower level associates that are just out of law school and getting their bearings, because a lot of what you're doing is just trying to figure out the lay of the land, and you spend a lot of time kind of like sucking up to people and just kind of like deferring to everyone's judgment. And so it's really hard because you're just used to communicating with people that way, where you're very deferential and you're the subordinate person. So, but hopefully, as you get more examples of people that it doesn't maybe even take that much sometimes to speak up, and it ends up not being a big deal. Whereas if you don't speak up, you spend a lot of time kind of churning emotionally about things and like what you should have said and you didn't say. So, that's right. Yeah.
You mentioned the research that the bar has done to collect these stories, or that you have done at least. Have there been any similar projects to maybe collect and implement training to change, that would go toward changing the culture? I've been an attorney at least 30 years now, and I've certainly seen changes over my time where people, I think, recognize that things that were maybe very commonplace 30 or 40 years ago just are not acceptable now. And I'm wondering how, or would there be a way to find ways to make where firms have made those successful transitions, make that available to others so they can copy or model it, so we hopefully have even fewer or maybe none of these kinds of stories.
I guess I work at a smaller firm and we don't have as much of an institutionalized kind of training, but I know that some of my friends who are like on this committee, on the diversity committee, work at larger firms in Des Moines, and I think that they've thought a lot of it is just getting younger people involved on the different committees that do things within law firms and doing presentations like this. I know Judge Scieszinski can probably speak to what the bar does, because it sounds like the bar has a lot of, or the judges have a lot more organized training that they've been doing for several years in terms of bias. And I know that they have implicit bias trainers that go through the bar. And I've been to some CLEs now where we're kind of doing more discussion about implicit bias and how it, in different aspects of their practice. But that's an interesting point about whether there's kind of a toolkit. I'm not sure. I know that in the, what was the name of this decision here from 2017? Yeah, Plain. I know that Plain references to some kind of toolkit that the ABA has put together, but that might be more for criminal cases. I'm not sure as far as just hiring practices, but I wonder if there would be some publications from the bar about that too.
I guess I'll answer that question, and then I have a question from a webinar participant for you. The American Bar Association Judicial Division, in which Judge Scieszinski and I are both very active, just published a book called Enhancing Justice, Reducing Bias. And it and also offers training on a regular basis for, I don't know that it's called a toolkit, but for specific strategies for reducing implicit bias from the bench. But many of the same strategies would apply equally to practicing attorneys.
It does seem like this is really catching on lately, and there are a lot of CLEs, a lot of trainings, a lot of publications. So I bet there's something out there.
Yes. So here's a question from a webinar participant. Do firms have policies and procedures for reporting these types of incidents? And what is typical protocol set forth in these procedures for addressing these types of incidents or comments that you mentioned in your anecdotal section?
I guess I do not. Again, our firm isn't set up like that because it's a little more of it's just a smaller firm. I don't know if anybody here is from a bigger firm and could speak to that, but I guess we didn't collect that in terms for this presentation. I don't know that, but I hope that there are some kind of more set procedures. I think a lot of people try to do that through mentorship too, by just having someone you can go talk to that's kind of specifically assigned to you. But yeah. Anything else? Anybody? Okay, I'll turn it over to Judge Scieszinski. Thank you very much.
Good afternoon, everybody. In my presentation this afternoon, we're going to recognize that the professional calling of all lawyers is to avoid manifesting bias, prejudice, and harassment with other persons. In calling out the culture, our next steps, I'll alert you all to ways in which the legal profession falls victim to implicit bias, demonstrated in sometimes the most amazing ways. And typically these are ways that the professionals involved don't even recognize that it's happening. This program will also highlight ways in which we can reduce the exercise of subconscious influences in the practice of law, and with the goal of leading to a diverse and inclusive profession that we all desire. So what would authorize an Iowa judge to come talk to you about something like this today? Judges are focused, at least in the 21 years that I've been a judge, they're focused on the fairness of what happens. And that leads to the customary question, well, is it fair? And in our new training that we're receiving, particularly on the national level and here in Iowa, where Iowa has demonstrated that it's a leader in addressing implicit bias, we're really getting a lot of perspective on ways that these subconscious influences can permeate the work of judges, and because lawyers are also human, the work of lawyers. The benefit of the training for me has been that it's illustrated the insidious nature of bias, even upon people who should know better, people that are really smart and educated enough that they should know better. And in retrospect, I think many of them do know better, as Ms. Messamer illustrated in some of the comments and the backstories of those anecdotes. I've also noticed a curious twist that even people who fall victim to subconscious biases don't develop an immunity toward exercising those biases themselves. In fact, sometimes their experiences form the basis for their defaults, their decisions, and their subconscious inklings going forward. So fairness would be my motivation in being here to talk to you today about this. And with that, I would have the goal of making our legal profession more inclusive, more diverse, and preventing harm through education, and also preventing harm by way of disciplinary action to folks that are unwitting purveyors of implicit biases. You might wonder what the legal authority is for a judge to come out and talk to people on subjects such as this. And I've just illustrated here a couple of insights from our Code of Judicial Conduct, which advises us that we may engage in extracurricular activities that are allowed by law and compliant with our Iowa Code of Judicial Conduct. We're encouraged to participate in activities that are educational in nature and promote the administration of justice. And there's always that caveat that we can't practice law. So on today's menu, this is not legal advice today because judges can't give legal advice. I'm not a psychologist. And unlike Ms. Messamer, who's a sociologist, I'm not a sociologist either. But I have a sincere desire to develop our profession and improve the way that we deal with people, and also give us some insight into the call for action, the next steps, if you were, to build a judicial culture and a legal culture that is diverse and inclusive. Well, let's take a look at the lawyer's responsibility. And this slide echoes the one that Ms. Messamer had up for you a little bit ago, but I've put in some highlights that would assist in understanding the gist of this. And then in a little bit, you're going to see why some of this gist is so relevant in Iowa right now. It's professional misconduct for a lawyer to engage in conduct that's prejudicial to the administration of justice. And it's also misconduct to engage in sexual harassment or other unlawful discrimination in the practice of law, or knowingly permit folks subject to the lawyer's direction or control to do so. And then in comment 3, it fleshes out a little bit what is actually meant by that black letter rule that is the disciplinary rule. Judges too have very strong guidance about exercising biases, and that is that a judge shall perform duties of judicial office, including administrative duties, assigning and managing cases and such activities, without bias or prejudice. That's without any bias or prejudice. And then in Rule 51, 2.3, subsection B, it fleshes it out that the judge shall not, in the performance of judicial duties, by words or conduct manifest a bias or prejudice, any bias or prejudice, or engage in harassment, any harassment, including but not limited to, and then there's a laundry list of types of bias, prejudice, and harassment that might occur. And this is the most exhaustive list you're going to see. You'll notice here that there are several examples given for judges that aren't set out in the lawyer's rule. But whether it's set out or not for judges, judges cannot exercise bias or prejudice of any sort. So if you come up with some new terms of common biases and prejudices, those are included in the rule. And then something that sometimes escapes judges as well as lawyers' recognition is that judges have a duty to require lawyers in proceedings before the court to refrain from conduct that manifests bias, prejudice, or harassment. There is a very instructive comment in the Iowa Code of Judicial Conduct, and I think Ms. Messamer might have even pulled up some language from that, that talks about the insidious ways that bias and prejudice are manifested, such things as rolling your eyes or winking or doing things that don't show up on a judicial record, but obviously happen in the courtroom or the proceeding. Well, here's a newsflash, and this is why, one of the reasons why I think our discussion today is so timely for Iowa lawyers. The American Bar Association has for decades, as you probably appreciate, served as a catalyst for defining professional responsibility. It does it for lawyers in the model rules of professional conduct. It does it for judges in the model code of judicial conduct. And in the end, most states adopt these rules with some state-specific tweaks. Our history here in Iowa is that the Iowa Supreme Court typically adopts these model rules with a few little tweaks in the past on such things as advertising rules, where there were some Iowa-specific tweaks. In 2016, the American Bar Association's House of Delegates adopted unanimously an amendment to the Lawyers' Rule 8.4, which defines misconduct. And that particular enactment has drawn a lot of controversy. It drew a lot of controversy as it was being developed, and it's drawn a lot of controversy since its unanimous approval by the House of Delegates. But basically what it did was it modified the language in subsection G of Rule 8.4 to eliminate a lot of the limitations that the prior model code provision and Iowa's current provision have on this kind of conduct. And so now the model rule would read that it's professional misconduct for lawyers to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of several categories there, adding ethnicity, gender identity, marital status, and providing that this is much more broad than before. It doesn't just deal with conduct in representation of a client or just in the practice of law inside of a law office, but in conduct related to the practice of law. Well, the inspiration for my particular presentation comes out of what's new in training for judges and I think lawyers also. Mindfulness is a big topic for us these days, which means all-in listening, watching, paying attention, being 100% in the moment, not checking your email, not thinking about something else. In fact, the example that I give when I train judges is if your grocery list zaps through your mind while a witness is testifying on the witness stand, you've got a problem because you just remembered that you had to pick up half and half at the grocery store, but you missed what that witness said and you missed the demeanor of that answer. And that's a big problem. Nobody should want a judge that even has a momentary lapse like that. And similarly, nobody should want a lawyer representing them that has momentary lapses, that might be checking email while the client's talking, or might be taking notes in the margin about something else that needs to be done on another file while talking to a client. So mindfulness is a huge issue for us all. Our training is also honing in on recognizing biases, things in our backgrounds, our experiences, the notions we've developed. Sometimes we think of the savvy or the experience we've developed, and how those biases impact our decision-making. And then there's an emerging line of training, and I would say that ours today falls into this category of taking on the cultural defaults, individuals, organizations' reliance on bias-driven processes. You might notice that a lot of this new training hones in on the soft skills, the qualitative aspects of judging if you're a judge, and the qualitative aspects of representing clients if you're a lawyer practicing law. I'd like to give some attribution to Kathleen Nolte, who is a Denver lawyer who has written quite a bit in this area. And we had an earlier question about whether there were toolkits or resources to look to, and there are a number of them out there, and more lawyers are devoting a significant part of their practice to helping lawyers understand cultural defaults and the work of subconscious bias and prejudice in their practices. The book that I draw some of my presentation from today by Kathleen Nolte is called Going All In on Diversity and Inclusion, the Law Firm Leader's Playbook. And so even though this is geared toward a firm setting, I found the information in here to be very, very helpful and right on point for even judicial training. So I could recommend that to you. And also, I've been working with a law firm in Chicago that devotes its entire practice to helping lawyers avoid disciplinary actions based on bias, prejudice, and harassment. And that's the Allison Wood law firm. And if you Google Allison Wood's name, her website will come up, and there are lots of things available to people on that website, such as a primer for avoiding problems under Model Code or Model Rule 8.4G. So here's our charge today: to confront unconscious bias. You know, it came as a surprise to me, and perhaps it would also come as a surprise to you, that at least 80% of the function of our brains is unconscious. And scary about that, our conscious mind is oblivious to this working of the unconscious mind. So really, as a human, we're operating in tandem. We have this conscious self that says, I have no bias, I'm a fair person. And then we have this unconscious self that harbors stereotypes and attitudes that leak into decision-making. A complication in our charge is that we live in an evolved culture. And there are lots of definitions of culture out there, and the one that I've zeroed in on is the social studies usage, the sociological usage. That being that it's a way of life of a particular people, as illustrated by their normal behavior, their habits, their attitudes toward each other, and their moral and religious beliefs. So we'll take a little quiz here about culture, because the use of culture in this context sometimes comes as a surprise to people, because we may have grown up or thought about culture in different ways. So here's question 1. A culture springs from every grouping of people. What would you say? Is that true or false? Okay, true. Yay, right answer. Quiz 2. The quality and quantity of art and books at a courthouse dictate its culture. I hear people saying false. That's right, that's false. Good to have art and books in a courthouse, but it has nothing to do with courthouse culture. The culture of a law firm profoundly impacts what happens there. You bet it does. That's true. Next question. Culture is a group thing, so an individual has no real impact on it. False. Cultures change, and one person can be a change agent. Next question. Culture is a dynamic force at play within the legal profession and the judiciary. You'd better believe it. Barriers that appear in the exercise of a culture really make it personal for some people. And what we see is that some individuals, some groups experience uneven, less, or sometimes no access to all kinds of things. Networking, either informal or formal networking. Insider information. Can you see how cultures would develop that would just exclude somebody from insider information? FaceTime with the decision makers, the people who are influential. Mentors and sponsors, crucial people in a professional development context. Meaningful assignments. It's easy to see how somebody who is in a group that has uneven, less, or no access might not get meaningful assignments. Candid and frequent feedback, another crucial aspect of professional development. Social integration, how important is that in a group, in a law firm, in a judiciary? Training and development opportunities. Contact with people who advance careers, promotions, recognition, honors. Have you ever noticed how people who get honors and recognition seem to get a lot of them? They're connected. Types of bias. And this is one of the things that Kathleen Nolte talks about in her book, Going All In. And it really helps us break down how these cultural defaults develop. So the availability bias, a human, lawyers, judges, automatically employs top of mind or available memory. A good example would be what just comes first to your mind when you see a female going up the courthouse steps with a computer bag. That's changed a little bit, but there's still a fairly pervasive presumption that that's the court reporter and not the lawyer or not the judge. An example in academia might be that there's a presumption that all STEM teachers are male, science, technology, engineering, math. Another type of bias is attribution bias. That's where a human gives inner group people second chances or the benefit of the doubt, and outer group people less benefit of the doubt. And typically it's through the employment of stereotypes. A good example of an attribution form of bias would be the assumption that to be a successful lawyer or teacher can be judged by what school you went to, what law school you went to. Wrong. Anchoring bias, another type. That's the human's tendency to take an initial valuation and let it influence the final evaluation without awareness of that interplay, that the decision was reached early on. An example that's given for anchoring bias is, it's been observed that female lawyers, or maybe females in any kind of a profession, evaluate themselves more critically than male professionals in the same context. And so an anchoring bias would focus in on how hard the female performer is being on her own performance and just leave it there and not have an objective evaluation otherwise, just leave it there with that anchor. Another type of bias is confirmation bias, where a human zeroes in on what confirms existing beliefs, ignoring contrary information. That's an easy one to understand, sort of the echo chamber dynamic. We love to pay attention to what makes us feel like we already know the answer. I experienced confirmation bias during the 2016 general election, because I have wonderfully diverse Facebook friends, rabid Republicans, rabid Democrats, rabid independents, and they're all relating their viewpoints on Facebook. Of course, I can't relay my viewpoints on Facebook because judges are apolitical, but I could read it all. And when it got to critical mass, where there was just so much of it coming in and there's just not enough time to read it all, guess which ones I read? The ones I agreed with. The final type of bias is affinity bias, where a human gravitates toward like people, under investing in people who are different. A good example, and this is one thing that Kathleen Nolte maintains to fuel attrition rates in law firms, particularly, who's getting invited to the networking events? Who gets the key assignments? Who gets mentored? Who gets promoted and honored? Who gets the benefits of just the best intangibles versus who's falling through the cracks? Okay, time for another quiz. And we're just hypothetically talking here, so don't get any notions that I'm talking about a specific example. But there would be specific examples out there. Okay, first question. Ivy League lawyers perform at a higher level. Perform at a higher level. Is that a bias at play? You bet it is. Senior partners get choosy at lunchtime, deciding who of the associates or the law clerks to take to lunch, to get a little mentoring, to get access to the decision makers, to have face time with people who can make a difference. That's a bias at play, isn't it? You watch the camo guy carefully for signs of post-traumatic stress disorder when he walks into a courtroom or up to a witness stand. Is that a bias at play? Yes, it is. How about this? Athletes prioritize sports with work duties second. Is that a bias? Yes, it is. Here's one we can all empathize with. An LSAT score defines a lawyer's competencies. Competency being the ability to take what you've learned and use it. That's a bias at play. When the LSAT scores follow lawyers into life, like real life. Here's another one. Law clerks for federal judges are the ones that earn my respect. That's a bias at play. One more. Business law has more gravitas than family law. What a bias. What a bias, and untrue. So the big problem with bias is it drives down a culture in a courthouse or in a law firm, or maybe even in a county jurisdiction. And how does that play out? Well, hypothetically speaking, again, conference rooms and courtrooms are less welcoming when biases are at play. Communications inside an office, outside of an office, internal, external communications are crippled. Mentoring needs fail to get recognized. Achievements and potential are blocked. Diversity and inclusion are dampened. Professional development is frustrated, and career building is stymied. So here are some debiasing strategies inspired by ABA training. First of all, become aware. And first step toward that is where? Here today. And identify stereotypes or assumptions that we all jump to. Individuate. That was a new word for me, but it's one that really fits this usage. You gather the particulars of a person rather than relying upon your stereotypes and your assumptions. Get to know people. A good example in a judge's line of work is when we sentence felons, it's incumbent upon us to read a pre-sentence report that is basically a little book that's prepared on that particular defendant and the sociology of that defendant's life and what was involved in this situation, just lots and lots of information. If you're going to individuate sentencing and make it unique and appropriate to an individual, you have to read that. And in our busy, overfilled court calendars, there's a lot of incentive not to read it, to stay on schedule and keep things moving. But it's hugely important to individuate and not just read a summary paragraph and then let everything else get taken over by assumptions and stereotypes. Here's another strategy. Replace your stereotypes. Displace the active ones. Once you spot what your stereotype is, it's not hard to figure out why it's a fallacy. Imagine counter stereotypes. Think of high-profile examples that dispel your stereotypes. There'd be all kinds of them. And you just proactively think of those. Take perspective. Step into the shoes of another. Proactively, like before the situation comes up, like before a sentencing, or reactively, afterwards. 6, increase contact. You build a baseline of rapport with people who are different than you. As that funny TV commercial says, we need more than just a bias monitor. You know, the commercial about the dental monitor. So it's incumbent upon us that we've got to do something about the play of these biases and stereotypes. So as we said about calibrating the profession, we had that earlier question about tools. Here are some tools to offer. Develop an inclusive intelligence, a frame of mind that's inclusive. And a good resource for that is the Next IQ, the next level of intelligence for 21st century leaders. They're cited on the slide. Identify blind spots in perspective and decision-making. Re-examine the salient identity among leaders. And this is something Kathleen Nolte talks quite a bit about in her book, Going All In on Diversity and Inclusion. Our blind spots cause us to miss some great qualities in people because we basically closed our list. Employ 3D diversity, where we value and incorporate innate, acquired, and developed diversities. Again, Kathleen Nolte talks a lot about this, and these terms might be self-explanatory, but innate qualities are social identities that we're born with, like age, gender, ethnicity, and also personality traits. Acquired identities are those social identities that you have some power to change, like marital status, occupation, military status, parental status, education, socioeconomic status. And developed diversities are social lenses that are intentionally developed by making them desirable or more salient. Things like generational savvy, or a racial awareness, or gender smarts, or disability appreciation, or religious or cultural dexterity. And then another strategy is to train yourself to flex so that you can shift automatically to optimize preferences, values, views, and norms. And there's a citation there to a playbook for managing across differences. So next step for lawyers, acknowledge our own humanity, which makes us totally susceptible to the play of biases and prejudices and cultural defaults that we might fall back on. Face up to the interplay of bias, even by the victimized. And I made reference to that in some of my opening comments, that it would be easy if you had been victimized by bias or prejudice or harassment to exercise your own, to stay away from certain kinds of people, assuming that all people will do that same thing to you, all people of a certain nature. Well, that's not true, and that's unfair. Cross-train, acknowledge the impact of culture, first of all, and institutions, and then cross-train, identify hidden barriers, practice personal discipline, instill an organizational ethos, and commit to be a leader, to be an agent of change. And then, of course, seize the teaching moment, like we're doing today. So before we move into our second part of this program, are there any questions out there about this material?
On a couple of slides ago, one of the things to do was flex. Could you explain more what that means?
Because not every situation calls for the same response, and the same level of intervention and application of personal discipline. You just learn to flex to figure out what's appropriate in a given context. So if you recognize, for example, that you're uncomfortable around Black people, if that happens to be something that you recognize about yourself, well then instead of going through all the strategies, you would do the things that proactively get you to a comfort zone. You'd get to know those people and you would individuate. You know, you would, whatever stereotypes you might have, you would displace them affirmatively. And yet a bias or a default of a different nature, you would pick and choose what intervention strategies were necessary and be able to move back and forth. Now, I can appreciate that this sounds like a bunch of mental mumbo jumbo, you know, to do all of these things when you're doing what takes up all your time anyway. But after having the training on the national level and practicing some of these techniques, you can see them at work in your own practice. And there are things you can adopt as practice pointers or your own professional development brand where you just will always do something. A good example for me, I always dig into the pre-sentence reports, dig in, read every word of them, think about them, reread some words of them. And that's my personal brand. That's not a universal practice, but for me, it's the way to individuate on that defendant. And that's not based upon the race or ethnicity or age or personal characteristics of the defendant. In my brand, it's based on them being a defendant and being in that position where they're entitled to a fair and independent assessment of what sentence is appropriate. That's a great question. Any other questions or comments?
Do you have some tips on how to practice these? Of course, as you're going about your daily duties, but maybe more of an exercise to train yourself or to train ourselves how to make sure that we're consciously employing all of these strategies?
Well, that's a good question, and some of that we'll dig into a little bit in our second session, but first of all, you have to recognize what your pitfalls are, you know, what stereotypes you're calling up and what biases and defaults you have. And, you know, like I said before, sometimes these disguise themselves as savvy experience. I rely on my experience. That can be a dangerous thing, you know, if your experience is loaded with stereotypes and biases. And so once you identify what they are, then you'd go through the list of things to do and figure out, figure out which ones apply, and proactively apply them. And you'd have to do it consistently to make it an automatic, because the goal is that it will be automatic. When you're confronted with a situation like that, you're automatically going to employ a fair standard, a fair approach, rather than letting those easy biases infiltrate your decision-making. Any other questions? Any questions from our people on the webinar? No? Well, we've had you captive here 2 hours. Let's take a little break so that folks can head to the restrooms. And for those of you on the webinar, Be sure to come back. What should we say, Christy? 10 minutes? And what's our computer read right now, time-wise? 2:30? So come back at 2:40. Okay? We'll see you then.
They're kind of like freeze. Well, that's true too. And yeah, but
So what exactly do you do?
yeah.
All right. So you probably get quite the grip.
I do, but the Attorney General's office does the litigation piece for some of that piece. So
Do you kind of manage the litigation stuff like you're?
not so much. I mean, I think they're pretty good at just, there's discovery, whatever. I mean, those processes. But no, I'm pretty much just I say do a lot of training, make sure, especially the criminal cases that we get, updates pushed out. And this is more just kind of for the CLE piece of it. But I also know Judge Scieszinski. I used to be a prosecutor down in Dave District. So,
Oh, really?
Washington for a number of years. So, anyway,
Really powerful anecdotes.
Okay, good. It's kind of hard to tell.
oh, yeah.
Yeah, nobody reacts. It's shocking.
Yeah, some more.
In this day and age,
Uh-huh.
in an earlier time, not that they were okay then, they were shocking then, but they're more shocking now.
Right.
Where have these people been living under Kent law?
I think sometimes that the shift is, well, certainly the overt things I think have gotten better, but maybe what has happened is there's been more of a certain things gone underground in the culture that, like I say, you still the exclusion from the power circles, or still the, you're on the right track when you get honors and recognition, and it's kind of a secret handshake kind of going on. But and I won't interrupt Judge Scieszinski's presentation, but
There'll be plenty of chance to interrupt.
well, I was gonna say, I think we both have some stories about some people.
I bet.
Or
I'll
not,
have a little bit of a
or
tickle.
deceased or retired. It's like, oh, brother, it was something else. I'm just looking over maybe the bottled water.
Yes, do. We should all.
No, I think it's still disturbing and uncomfortable that, we're still, sort of gauntlet for new associates, whether they're people of color, whether they're, women, and I think that, it has gotten better, but I'm still wondering how can it get more better. I'd like to see it start with the law schools. Why are we not being able to get more people of color and women, through the process and into the practice? Really help us a lot.
That's the other thing that diversity committee did was like they're kind of setting up mentorship programs with Drake in Iowa.
Yeah.
And I know I haven't done much with the Iowa one, obviously, because they're just not here, but we've had Drake people that like we've hired on this person. So from just kind of because you get to know somebody, like, hey, I did somebody to fill this job, so.
Right. And like I say, they get to know more, other than the grades or what they've done in school, which is all important. But like you say, you get to know them and say, I like that person, I like what they bring to the firm, and give out. I mean, because you mentioned Justice Waterman, who's a classmate of mine, distinguished themselves very, very well. But if you also look at it, okay, their firm's been in existence for 100 years. And so the kinds of networking and things that are just sort of automatic for someone, you know, as a family business, other people may not have those connections. And so like you say, making a special effort to reach out and say, hey, we're interested in you. You've got potential. We like what we see. And you can help fill some of those gaps. So I'm very encouraged. I don't know, what's your firm now that you're working at? Okay. Oh, I didn't know, you said about a smaller firm.
I guess I'm like thinking like, you know, like the big ones,
Well,
the IRA committees, we kind of just like, that's like people love me, like, oh, yes, I like that person. Yeah, but I have a couple girls that I've been meeting with from Drake that are both African American, and it's kind of neat to hear them say, I think even Drake has like some larger classes of African American people and how much of a difference that's made to them. From like starting out, they were like, kind of smaller class right now, like income class, they're white people, and feel a lot more comfortable there.
And that makes a difference too, because, you know, just like, I was thinking, okay, I uprooted and went to Africa, but I feel as comfortable there as I feel here. Probably not. Different culture, being a minority, a lot of things. So, you know, it's just something to recognize.
Okay, yeah, so I'll think of more anecdotes if we need it. So I wanted you guys to present your whole thing, but yeah, I have some anecdotes.
You got anecdote?
I do. Well, here's a funny one. Okay, so I'll tell you that. It's not legal. My stepdaughter is, well, she's a softball player, and then she's a softball coach in the Des Moines school district. And
We went off mic, right?
she did it for 2 years, and I think it was after the first year, maybe the second year, she's like, I think I'm the only high school softball coach who isn't a lesbian. And I thought my way around the other, I was like, yeah, you're in, I go, you're in the minority. How do you feel about that? And she's like, oh, it's okay. Because these women happen to be really great mentors to her, and were great role models. It's just funny because it took her a year to like figure out maybe this difference.
And you just get these niches, I suppose it could be different,
but yeah, it was funny, and that was just it was just funny because I was like, what? See, you've always been in the majority your whole life, and now you're in the minority. How do you feel? Okay.
Does she still do that?
Yeah. No, she stopped after a couple of years, and then my son was, talking about that. His whole life, but he was joining my track club, and we knew some of the parents, we knew some of the kids in it, and they happened to be either African American or biracial families. And we're driving on the way to the first practice, he just asked, and he's like 10 or 12%. Am I going to be the only white person? I was like, I don't know. We'll have to wait and see, when we get there. Because I said, I honestly don't know, and neither of us had really, thought about it. And it didn't, and it didn't make a difference until we got there. And it was like, he was a minority, but he wasn't the only, But it was just funny because it just like had dawned on him. We were talking. He's like, who else going to be there? And I'm like, well, so and so and so and so and so and so and so. And he's like, oh, wait. Yeah, well, that's a good experience for you. So,
That's nice. That's nice to think of being a bigger town. More interaction.
Yeah.
Does your daughter teach too?
Yeah, she actually she's teaching Head Start right now because she likes the younger kids, and she was in college at the time. She was an elementary or education major at Central College in Pella, and then she mostly coached during college, and then I think the first year out after, and then she stopped because it's hard to do with a full-time job because practices and games are in the weekdays. Oh, I know. Oh yeah, they definitely did it. Just do it for love, the love of it. Yeah. She really liked working with the high school kids. Yeah, she loved the college. She stopped playing when she started coaching. Yeah.
Oh, were you at PCWA lunch? Just the last one they had out, where they had, I have a dream, people come speak.
Oh.
They're just talking about Central because they said they like adopt this whole elementary and they take on colleges every year.
Mm-hmm.
Here's a comment.
regard to Gina's presentation.
That's nice.
Kind of gets to that point of champion.
Mm-hmm. Yeah, definitely.
How do you think we ought to recognize this comment? Just read it?
Yeah, maybe sometime we can kind of fits in, you have like a,
Or maybe just write it in the house, actually, good spot, and maybe people want to weigh in on that. I think
maybe 5 minutes in.
welcome back, everybody. We're heading into the second part of my presentation, and this is a fun part because you all get to participate. However, before we do that, I want to recognize an online comment that came in, and I think this may have come in with reference to Ms. Messamer's presentation. Let me read the comment, and then we'll ask Ms. Messamer to respond to that. The burden is primarily on white men. I'm a white male attorney who is sick of having other white attorneys make bad comments, sex and race, and assume because I'm a white male, I'm okay with it. Much like the example mentioned, it is not up to the African American attorney to stand up, but others. Maybe recent published famous people will push change. We can only hope. So Ms. Messamer, any comments you'd like to make as a follow-up to your presentation on that front?
It makes me think about how I think a lot of the kind of stories that I read and comments that we hear are made by people who think they're being funny or think it is acceptable. And when you make those kind of comments that you think are acceptable, everyone who's around is kind of complicit in it when you don't say anything. And so, and it is probably more comfortable for the white male or somebody who's more of a peer to the person making the statement to say like, hey, I heard that and that was probably a little too far. I think it might have made that person uncomfortable. It's easier for that person to stand up than the person actually made uncomfortable, I think, because it's more personal to that person. So I think that's a good point.
Sort of that champion that you're looking for. Yes, a good comment and great introspection. Well, we're back to calling out the culture and looking at next steps for us. And as we look at today's next steps, we're going to have some audience interaction. First, we're going to reflect on culture and the capacity that culture has for change. We'll face up to the interplay of bias in various contexts. We'll acknowledge the impact of defaults at institutions and among groups and explore next steps to identify hidden barriers, practice personal discipline, instill organizational ethos, lead and be an agent of change, and then of course seizing the teaching moment. So we talked about that definition of culture, and this is just by way of review, that the sociological definition of culture is the way of life of a particular people, shown by ordinary habits, attitudes toward each other, moral and religious beliefs. We're going to reflect on culture here and have a group function to spot the sociology of a group. So we're going to discuss in small groups where you've observed culture change and what was the cause of the change. For those in the conference room, I'm going to ask you to get in groups of 3 and discuss this. And for those of you on the webinar, you're there by yourself. The big challenge for you is to be mindful and participate in this particular part of our project. So please don't check your emails. Please don't run out and talk to the front office staff. Please don't go get a snack. Sit and think about this, and we'd really like to have your participation in it. So starting now, we'll have 5 minutes, resuming at about 10 minutes until 3. And I'm hopeful that there will be some folks that will be willing to report back their observations about how culture's changed and what's been that change agent. So, time to discuss.
How did that develop? How do we replicate it? And I don't know much about it. But I just got very because we want to belong to groups, make us feel good, or make us feel like they're doing things the right way. I mean, I think we should find ways to jump on that bandwagon too, and say, here's some leader, here's some people that are doing it right. How do we make it better?
That's really important that they're, that practical guide for all types of diversity. Just like hiring that will be in firms and government, that I was earlier, yeah. Like, because yours really is like, it's obviously created in hate. Okay, like you said, if something that makes sense in hiring, high that, they're gonna be respectful. Yeah. Did you do training or?
I'm starting. That's what I do.
Yeah. And do something like that. Exactly.
In order.
I'm glad to see that.
That sounds it. You miss it.
Welcome back, everybody. Please know that we watched the minutes tick by as we were on this break. The discussion here in the conference room was very lively, and we had tremendous response from our online webinar participants. And we've been in the process of getting those printed out so that we can share those. First of all, here in the conference room, anyone want to share a culture that you've seen change and what the change agent was? There are microphones here. We'll need to...
We talked about the change in sexual harassment, and it is obviously it has exploded, beginning with Weinstein, and now several hundreds of men probably are out there thinking they're in trouble, and they are, and they should have been. We talked mostly about that change in our culture, and we talked about the cause of the change. Maybe one of the other ladies can.
Yeah, we talked about the cause of the change. A big part of that was social media and the Me Too movement, and kind of the almost safety in numbers and kind of public accountability that caused it was probably the big cause of that change.
We talked a little bit more about it. It seems that the more women who come forward as part of the Me Too movement, that their statements are now validated and more likely to be believed, as opposed to being dismissed or swept under the rug.
Your group's observation mirrors that of our comment 4 from one of our webinar participants. And that person cited as the agent of change that there was actually some accountability. Things were happening, people being fired or choosing to resign, and that lending momentum to the change. Other observations from the conference room?
Okay, I think I'm on there. I thought an interesting one. I've kind of moved around so much since I've been out of law school that I haven't been somewhere long enough to really see that much change. But my table mates, one observation was just kind of in work-life balance and how he used to go down. I'll just like.
Well, back before the earth cooled, when I started practicing, Saturdays wasn't particularly a work day, but it was a day that you went to the office and you opened your mail, took care of, dictation, but principally you were down there to be seen and to see other people and to talk to them and socialize with them. And that was every Saturday. But when today, probably starting 10 years ago, we actually, we had a reception, we had a receptionist on site, and we had phone and secretarial work. We don't have any of that anymore on Saturday. If you're down there, you don't have any professional, assistance. And it's gotten to the point that hardly any attorneys go down there, and which maybe not so bad in the sense of work-life balance, but in the sense of socialization of the law experience and the practice of law experience, it's diminished that aspect of it pretty dramatically, as a matter of fact, because during the week, you don't have a lot of time to do those things. When I first started, the entire firm ate lunch together. We all knew everybody very well, and that doesn't happen anymore. We're just too big, I think. So that has changed.
And so the agent of change on the Saturdays, what would you say that is attributable to? Change in turnover of people?
In a way, the driving force behind coming down on Saturdays was the tradition of coming down on Saturdays. And people just started kind of winging off and doing other things and having other priorities in their life other than coming down. And as a result of that, the firm became less familiar with each other as individuals, and as a group, you know, we could talk about firm problems together in an informal basis. That doesn't get done very much anymore. So the agent of change to me is the difficult question. No question about the change. The difficult one is, you know, what made it happen, and that's your question.
Yes.
I can't really. Our experience may have been different than a lot of other people's, but I think it's pretty broad-based.
Well, let me reflect on some of the comments that came in from our webinar participants, and it looks like we have 22 comments. I won't go through all of them because there's some repetition, but the first one is attitudes towards transgender people has certainly changed recently. The cause of the change is general acceptance in society, and that it is talked about a lot on the news and TV. Comment 2, I believe that the main reason that the culture has changed for the better is that with all of the publicity and attention that's paid to the issues, it's made people more mindful that their actions, of their actions, and that harm could result. There appears to be significantly less blue jokes and discussions around the water cooler. And then there's an observation that dress codes have changed dramatically. Here's another comment. I believe culture has changed since 9/11. Those of us who watched cannot help being scarred by the memories of young terrorists who looked the same, adhered to jihad and the like. And then another comment, while many of us fought not to lump all of one religion into the terrorist stereotype many have, any comments on how to combat the real fear many have? Any comments? Here's one. Society is less respectful. Men wear hats in places where in the past they would have been removed. Dressed by both male and females is less formal, almost to the point of sloppiness. We do not respect authority as in authorities are perceived as having taken advantage of we the people. Respect must be earned, but respect is not given. As a result, the reciprocity of the past is not there. Any comments on the cause of change with the informal dress? I think that's one thing that impacts the practice of law and the judiciary is the lack of formality, and it's a pretty frequent discussion among judges about how to constructively maintain decorum and proper respect in the courtroom, and yet appreciate that some people don't have things to wear that we might traditionally find acceptable. So any comments about what the cause of that change is?
I'm not sure. It's something I've noticed too, and I know some of us jokingly talked about when we started practicing law 30 years ago, we had to wear a blue suit, we had to wear hose, we had to wear, you know, heeled pumps, shoes, and a, you know, blouse with the little ties or something similar every day. And then of course it's much nicer to be, you know, dressed more comfortably, but there's a line that seems to have been crossed, you know, more times than not recently. And I know a few judges, especially here in Polk County, who reprimanded both men and women who he or she believed were not dressed appropriately, showing enough respect for the court and the courthouse setting. I know when I served in a supervisory capacity for some, you know, fresh out of law school attorneys at a previous place of employment, I felt like I was their mother, but telling them, you're going to go to court wearing that. But, you know, and of course, I never actually said that, those exact words, but something along the line of, well, some of what Gina's or Ms. Messamer's comments were, or some of the anecdotes were, you know, as women, we need to work harder most of the time, especially when you're first starting out in practice. And part of that is, you know, making sure you're dressed appropriately and showing proper respect for the court and the courthouse setting or the other settings where you find yourself early in practice.
We've had several comments about technology. In fact, one was a follow-up to Mr. Van Orsdel's comments about the changing practices on Saturdays. Speculation that maybe it's the technology that's encouraged people to work from home and not see the cost benefit in driving downtown to accomplish what could be done on the computer at home. And then there is another comment about technology and the practice and how it's changed everything in daily lives, and why not in the practice? Changed home security, holiday shopping, order groceries online, and so forth. I actually have a reflection on how technology has changed things dramatically in the judicial system, and it's way beyond just going paperless. When I started 21 years ago, all judges in Iowa had a personal computer that was sitting in a box because everybody had been issued one. And for the most part, they didn't know how to use them. A few people did, and I was just coming on the bench then. And I didn't know how to use a computer either because I had been dictating all of my work in the law office because we had staff to type that up. And the staff used computers, but I really didn't. But I set about learning how to use it. And it actually was controversial. I was admonished by the court administrator at one point about 9 months into my judicial career that I was using my computer too much. It was looking too secretarial. And that was in a time when lots of folks weren't using their computers, and the ones that weren't using them were really very proud of that fact, that they weren't using the computers. And then as things became more technologically advanced and we started relying on email for communications, it shifted, the culture shifted from that extreme pride in not using computers to just sort of being silent about it, kind of pretending that you used computers by your silence. And then eventually, you know, maybe 5 years later, we moved to a point where people had started to use them and they're very proud of the fact that they can use them. And so the boast that started out, I don't use my computer and I'm proud of it, became I use my computer all the time and here are all the things that I can do with it. And I think in reflection, the agent of change was probably twofold. There were a handful of people like me that were showing folks that you could really accomplish non-secretarial things with a computer. Not that there's anything wrong with secretarial things, because many of us have found great innovations and cost efficiencies in doing word processing without secretarial intervention. And in the judicial system, because we don't have that kind of help, typically it's a necessity to be able to do your own word processing. But the other obvious agent of change has been the state judicial policy going to a paperless system where computers just have to be used and have to be used efficiently. Well, we have quite a few more comments, but I think maybe the last one that I will mention at this point in the discussion, and this comes out of a couple of different comments about the coarseness of the debate on the national stage, maybe as first seen or seen most recently in the 2016 elections, and with the use of social media by politicians and the subject matter being the judiciary or the Justice Department or other aspects of government that might have traditionally been off limits for that kind of a discussion. And any thoughts on what the agent of change is there Is it social media or is it something else? Everyone is strangely silent on that one. Well, and we'll leave it that way. The whole purpose of this exercise is to cause us to think about culture, how people interact with one another and how that plays out in their ordinary habits and their beliefs, and how cultures can change, and how agents of change can be certain people, or they can be certain groupthink, or they can be something on, on a national level, but change can come from all different kinds of sources. So let's move on to the next problem. And this would be a little harder. It's a group function to face up to the presence and the play of bias. Discuss how bias has played out in your experience, either strategically or because it's a force of habit or accidentally, and what the source of that bias was. And I'm going to add an additional challenge to you. Let's don't talk about the ones we've already talked about. Let's think of some other examples. And just to kick off that discussion, I'm going to mention a strategic exercise of bias that I've observed numerous times in the courtroom. And it's where an attorney in examining a jury panel will be softening the jury up for consideration of damages in a civil trial. And the attorney will say something like, "Don't worry, we're not going to be asking for anything like $1 million in this case." And then they go on and maybe mention that a couple more times. And they don't say what they are asking for. They just say, "We won't be asking for $1 million." And then as the trial proceeds and it comes to closing argument time, when the damages that are being requested are actually disclosed, it will be $500,000 or $250,000 or something that makes it look like there's a fire sale going on. I mean, what a deal. And that's the strategic use of a predisposition, a prejudice, or a bias. It won't be as bad as $1 million. It'll be this. So think creatively back on your experience about where you've seen bias played out and the source of the bias. And this time, we will give you 10 minutes because it'll probably take that long. And so by my watch, it's about 3:15. We'll resume at about 25 minutes after 3.
Nothing immediately comes to mind. Good enough. Good enough, yeah. I get your point, yeah. Or I like, yeah, and I think I tend to like the stereotypes I have are like people that went to Drake did clinic, and so they've actually been in a courtroom versus maybe Iowa are better at research or something. Like those are kind of more of the stereotypes. It definitely is, absolutely.
And I don't think there's, my belief is that I don't think there's anything wrong with being biased. It's bias that is without hesitation, that doesn't have any foundation. If you go to a playground, more kids have brown eyes. But if you do studies, brown eyes tend to get
Really?
A lot of time on your hands.
and
Nothing else to do.
It's not isolated humans. I mean, we're in, let's say we're in the all different kinds of levels.
That's why you have the stereotypical group of blonde girls in high school that run the show.
Well, everybody.
Hey, everybody knows about blonde.
Yeah.
You saying that makes me think of just when you get applicants and you're trying to derive as much as you can from their resume and like concocting what this person is based on such limited information. I know I've gotten some where some people have list their hobbies at the bottom and you just make wild assumptions about their hobbies or like what kind of person they are because they like board games or whatever.
I think we're all biased in some respect to their life, but some of it may be, have some actual foundation, maybe justification for bias.
Yes, yes.
And
I mean, I have a bias that
piece that I
boys
found
are way
interesting, and
smarter than
it
girls,
made a lot of things make sense for me,
or maybe
is
say
that
that
when
elementary
people have
girls
been through
were driven
trauma or a high level of stress, it really
I experienced
fragments
that
your
in
thinking,
house so much.
your decision making.
I didn't have to do anything to get my daughter to study
I mean, I'm going and be in a car crash or something, but
work on
car
different
crash or a
levels.
bad storm or loss of
Or
job
something.
or whatever. And
He'd rather
suddenly all the
play
things
soccer,
that maybe you could
or
just do
he'd
step by
rather be
step by
doing
step
something
and do them
besides
fine.
his book.
Before that, now, you know,
That
even
continues.
your brain is working differently because it's under a lot of stress. And so
Two of my kids.
that I would
Well,
agree
my daughter,
with
she's the
what
oldest.
your
She
comment
is
is that,
driven.
granted,
Yeah,
she always was
there
at
can be
school.
some laziness.
Straight A's.
Completely.
My son.
We all have
I had to
the,
go to school.
we call them.
Yeah. Oh, yeah.
And I'd say that 10 years from now.
But on the other hand, as you mentioned,
Push.
it can, you know, especially and particularly for victims of crime, which is my.
She's smart enough. But if you could have been a straight A student as well, just didn't want to work at it.
It's hard sometimes when you're
To me,
talking to
it's
them or even
like, why?
Why? Look at what you're
be able
throwing
to
away.
recount what happened. Sometimes you can't do it chronologically. Sometimes it's episodic or sometimes.
It's probably a hard one to overcome than when it's your family and something you deal with so intimately.
To not, yeah,
What happened.
because you know
And
so
that I
many
think
different
can apply
facets of
to a
their
lot
life.
of,
Mhm.
I was in private practice for a little short period of time, but divorces, businesses, I mean,
My son didn't
you know, business decisions that can be very,
I had a dragon.
literally the future of
Mhm.
the business is hanging on what's gonna happen. It can be very similar, I think, type of
What do you
situation.
want to be?
So,
I don't know.
what's the source? I would say,
It took a long time.
in my
As a result,
case,
it's
I had a very normal, thankfully childhood where, you know, we're expected, here's a job, do it to completion. So my bias is, okay, you have a job to do, whether it's read a piece of paper or remember and tell what happened to you, well, why can't you just get that?
Your brothers.
I've got a younger brother, yeah.
So.
We do fit the stereotype. My brother lives in, he's 6 years younger and he's living in Chicago right now, working part-time at a restaurant.
Didn't understand
You know, yeah, he's
how that was.
the more fun one, you know, he's the.
Maybe to talk to
True.
Oh, we've got 3 people that fit the stereotype.
Because they will remember things
Yeah.
the second time.
Do you think that it reflects when you're hiring people or assessing people at work?
Yeah, now I remember.
We have probably an expectation that we get 100 applicants. Let's say we get 20 applicants.
So
That
I
more
think
of
it
them
helped
will be
me
qualified.
in talking to people and understanding
I have
that the way I see it.
maybe a 75, 25 split or something like that. We're looking for top 10 in class. It's more likely that there'll be women than men.
How long do you think that's been the case?
I don't know if you do litigation or not, but putting together and or more transactional. I mean,
Maybe since sometime after the late 60s.
so of course we're gonna read every piece of paper, and word on every piece of paper, or we're gonna.
That's a hard one because it hits so many different levels at different stages in people's lives and in
You're right.
states. I mean, some states are different than other states in terms of where you're metropolitan, rural, that kind of thing. There's so many variables.
Read everything.
That's me,
You're right.
Right, because that was
More dramatic
Yeah.
changes by the
Read things through, ask questions, and that was okay. I was told that was okay to do.
But that's what it is.
Yeah, and then thinking through how different it is for.
Do you do anything to try to compensate for that, I guess? Or it's just, is what it is and you take
No, we don't.
As
a firm,
experience of, oh, okay,
We don't want to do
now I
that.
see that
We want
in
to hire
retrospect,
somebody,
their lives maybe
attorneys to be or
drama,
attorneys and
chaos, chaos.
the sex
sure, I think, yeah, because it's like been really close to 50-50, and then I think a couple years have kind of bumped up. So I think it might be too early to tell for sure how it'll keep up.
Seems like lately, law school admissions are down. Then the next year, maybe a downward trend.
We started seeing some law schools actually closed.
Yeah.
Some schools were experiencing lower applications for admission. Some schools were experiencing a lower standard. Their standard of who would get into class dropped. But that didn't slow down. I think that has gone the other way again. I read an article a couple weeks ago. Our applications are back up. And same with B school.
When I was looking at the stats for that presentation, it's like for the last 10 years, the national number of voters has just gone steadily up. But I wonder at what point, when you have like these older generation that starts retiring, if that'll just drop totally back off and it's kind of artificially inflated because it's so kind of loaded that way.
It's funny when you mentioned that. And Dad dealt with, he was the kind of person.
I have a friend who works at Brown Winnick, and he said that they definitely can tell just from the Iowa and Drake having smaller class sizes that it's more competitive for
Many
associates and summer people coming in now.
about some, it's like, I don't know how they find a way to look at.
There aren't as many to go around. They've been offered from other firms earlier. It's kind of more saying those people right away.
Well, I think kind of away from it now, but when I was more actively involved in administration, we could see.
Welcome back, everybody. Let's take a look at some of our online comments about how we've seen bias play out and the source of that bias. Here's one: how employee benefits and perks are advertised, not as an incentive for all to embrace a healthier lifestyle, but to attract millennials to accept employment. So here's a good example of a bias being used strategically to target an audience for interest. Any comments about that? Here's another comment and observation following up on my example, I think, about use of bias as a strategic matter in a courtroom. It reads, urban juries will return larger verdicts than will juries in rural counties is a bias. The bias plays out in an effort to get venue in a more urban county or in federal court. The reality is that rural juries will listen to cases and will, when the evidence is fairly and properly presented, return a verdict in favor of a plaintiff. This is a bias that is frequently found in the attitudes of insurance claims adjusters and others who are not from Iowa. In some instances, the strategy is to find a county where it is believed a more favorable jury verdict can be found. Any comments on that? The source of the bias being insurance companies. Here's another comment from a trial attorney. We, of course, want to influence juries. Personally, I like to invite discussion in voir dire of bias, giving jurors permission to volunteer their attitudes on a variety of subjects by acknowledging that we all come to court with our own attitudes and biases, and we just need to be sure our client's case is given fair consideration. That's great insight, isn't it? And here's another comment. This has to do with the use of new pronouns for transgendered people and the challenge that presents to longstanding use of language. And the bias there being played out is
traditional gender norms and adjusting to a new reality.
Mhm. The conference room, what did you folks discuss?
We talked about what could be perceived as laziness, but may actually be, traumatized persons in all types of settings. And a couple of us have recently attended a CLE program on trauma-informed care. And just, so the source of the bias is us having normal childhoods, a high level of education, maybe being type A obsessive personalities, obsessing over details and seeing the whole picture and preparing witnesses and so on, where many of the individuals we're dealing with have experienced trauma of various levels. And, we've now learned, since we've had some training in trauma-informed care, is that impacts their thinking. They're not necessarily thinking straight when they're in a stressful situation. They're more likely to freeze than to provide the testimony that, you think they're going to provide, or to, read and follow directions that appear to us to be very simple, or just otherwise behave in the ways we would expect them to behave. And that's because they've lived a very different life than we have.
Other discussions? Well, here's some more from the webinar participants. The first one references a bias being exposed by an attorney, and it reads, "We have a fairly large immigrant and refugee population in our city. There is an attorney in town that likes to brag about how well he works with them. One time he even bragged, 'I got a Sudanese guy to plead guilty. I think I deserve a medal.' I'm thinking that this played out as habitual or accidental bias. That is, there have been anecdotal tales of a small number of refugees over the years who have insisted upon criminal trial even in the face of compelling or overwhelming evidence, especially if that defendant was acquitted at trial once before. I remember a public defender saying his client was addicted to trial after having been successful in his first one. Back to the original attorney, though, his bias might have been out of habit from a past client of his own, or it could have been accidental given anecdotal tales he heard. Any comments on that? Shows that how easily stereotypes can develop. Here's another anecdote. Several years ago in a trial in a rural area, I made the decision to not present either a video or in-person testimony by a doctor who was Black. He was on staff at the University of Iowa hospitals and clinics and was highly qualified. My sense was that he would not sell well in this rural area. As a result, I had his deposition read by an attorney colleague. My concern was that the jury would be biased because the doctor was Black and would discount his opinions. My decision was strategic, but as I have thought about it over in the passing years, I wish that I had obtained a video of the doctor's testimony. He was very good, and I now believe that he would have helped the client significantly. Any comments? Here's another. I really think technology and social media have enhanced accountability and given a voice and platform for anyone to speak out against any type of bias or injustice. That's true, isn't it? Here's another example of how strategic bias played out. A Batson challenge and civil trial where defense counsel exercised peremptory challenge to exclude a potential juror on the basis of his responses to questions, and plaintiff's counsel's objection and raising of Batson issue. The potential juror was Asian and the plaintiff and plaintiff's counsel were Black Americans. The court granted the plaintiff's motion. Any comments before we move on? Thank you for the great participation. Well, let's look now at the impact of bias. This is our group function to acknowledge the impact bias has on real people and real issues. So we're discussing now a victim or a victor or both that you've observed in a play of bias and what the outcome was. A victim or a victor. How this plays out personally for people. Remember, we talked about how barriers, biases, prejudices in a culture become very personal when they affect people. So let's just take 5 minutes for this one. It's 25 minutes until 4. Let's resume at 20 till 4.
I just think it's simple things like of being the victor in some of these, like we just had Christmas gifts and I was going to return something without a receipt, and I just kind of know if I go to a store and return it, like they're not going to think I'm suspicious that I don't have the receipt. It'll be fine. You know, just little things like that where I feel like I look respectful enough, and so nobody's going to think I'm up to no good.
For some reason, her mother-in-law didn't like Golden Star. And so she would buy Christmas gifts for the younger two, but she never bought for the oldest. And so.
Get myself thrown out.
Space for like 2 years apart or less. And so my friend, her way she sort of matched that with this family gathering, she'd always make sure that there were presents for her oldest daughter and didn't necessarily identify them as from her mother-in-law, but would present them as they were. And it took a long time, and finally her daughter, in hindsight, as she grew up, said, you know, I don't think Grandma ever bought me any presents, just you're right. So, I mean, the kid sort of, I mean, and that's just, that's the only thing I can think of in terms of bias. Why that was the case, who knows? But that was just how she played that. She liked the other two, she liked the oldest one. And it wasn't even sensitive enough to figure, okay, I can like the other two just fine, but at least buy all three of them a gift. Don't buy
Same for, you know, like enforcement in certain neighborhoods where you just kind of have, I think there's generally more suspicion that somebody could be up to no good if you're out late, you know, even if nothing's going on with your car, if you're out after 2 a.m., maybe you might be drunk.
Yeah, no, she didn't. And which, you know, then she, of course, opened up to also process Grandma was not. But I don't know. But I think.
So, checking on warrants.
I don't know. I think I would have to hear from somebody that maybe really was impacted by, you know, being excluded, you know, what kind of, you know, how it affected career path, maybe their family, how it affect, maybe just how they, you know, maneuvered in daily life. I don't know.
Rougher area neighborhoods in town. So he's central, what's called the central, which is, let's say, Riverdale University or University and Martin MLK. I don't know if you're familiar with MLK over to East 14th. They know that those are high crime. I mean, they've got statistics on them. And so, in a way, so the police department tends to have more cars on the street in the areas of high crime. But he doesn't do that anymore. He doesn't pull somebody without some clear justification of something other than a broken tail. They don't do that anymore. And the reason, one of the reasons they don't is because of they're taking their own lives in jeopardy in today's society. I mean, it's like the police chief said the other day. He said, when I was growing up, people had disagreements. Which went out to the schoolyard. So, yeah. Today, they pull their guns. It's a that's an isolated situation. It's not fair to have that micro experience turn into a maximum experience. So that's what all policemen or that's what all police do. But targeting minorities.
Whatever it is.
But it's the impact of reducing crime. And so you're kind of caught between a rock and a hard place. In New York, they dramatically reduced crime by doing that. They stopped doing that. But that's probably what we're talking about, kind of a small segment of bias. It's a very difficult concept.
I've got a client right now where Kenny's bail bonds was looking for somebody who'd skip bond and called the police and said, hey, we found this guy, you need to go pull him over. And so they pulled over my client and he was just the entirely wrong person. But the information Kenny's had was that he had dreadlocks and was driving a car from Texas. And that was all they had to go on. And it just happened to be another person with dreadlocks and a car from Texas. But it kind of made me think, I think that's the part about being a minority is there aren't so many people with dreadlocks. You wouldn't say like, oh, a brunette guy driving a Wisconsin car, you wouldn't just go off of that. But when you have kind of like dreadlocks, you think, oh, this must be the one. There can't be so many of these guys around.
Welcome back, everybody. Let's have some sharing about observations we've made of how impact of bias hits a person as a victim or a victor. We don't have any online comments yet, and here in the conference room, do you want to share what you folks talked about?
I just have a little one of just an example. I think when you are dressed nicely and you look kind of what the normal is, which I think I kind of generally do. And I was telling the story of how I had to return some things after Christmas, but I didn't have a receipt. But I kind of we were talking about whether that was going to be okay and if somebody would let you, because one of the clothing items still had that little ink thing on it, and maybe they'd think you stole it. And I was thinking, oh, I look normal enough. They're going to believe me that this was just a mistake. But I think just little things like that you benefit from because you look wholesome enough that people would trust you.
You don't fall into a stereotype. Okay. How about the other group?
We were talking generally about language access and the fact that so many languages are spoken here in Iowa now and the need for interpreters in all types of legal proceedings. Talking some about, the recent appellate court case, which I can't cite at the moment, my apologies, but where a criminal defendant said he did not want or need an interpreter, and the district court judge insisted that he have an interpreter, and then the appellate court, reversed and remanded for a new trial because he had the right to say he didn't want an interpreter. And it's my understanding from reading the case that the criminal defendant didn't want even a standby interpreter because he was afraid the jury would be biased against him if he needed an interpreter. So I thought that was really interesting. But then talking about, the need for interpreters in various proceedings, and if a person's afraid to ask for an interpreter when they really need one, or and afraid to say the specific language or dialect they need, then that can damage them. That can certainly affect the outcome. And then, making sure if the person doesn't need an interpreter, it's a wrongful showing of implicit bias to assume that a person needs an interpreter if they're a recent refugee or whatever the case might be in wherever the legal setting.
It's a complicated dynamic.
Yes.
We do have some online comments that are coming from the printer, and while we're waiting on those, I'll share an example of some bias I saw played out, and I don't think the victim or the victor even knew about it. And it was in a group evaluation context where employees were being evaluated by a group. And we had 3 employees that were operating really at the same level of work, doing excellent work. And 2 of them were being rated higher than a third. And when it was inquired what the reason for that was, one of the evaluators said, well, I just don't feel the same around her. And I didn't say or do anything at the time. It's always on the drive home where you realize what you should have said or done. And what I should have done was dig into that a little more and find out what the basis of not feeling the same about a certain employee was. But as I reflected on it, the 2 employees that got the higher ratings were people who dressed up, they wore skirts and they wore high heels. And the one that didn't get the higher rating wore pants and flats. And that was the only difference I could really discern among them. And because their work was all excellent. And everybody agreed their work was excellent, but one evaluator didn't feel the same about the 3rd employee. And I think that was accidental bias. I'm not sure that that evaluator knew why he didn't feel the same. You know, it might have been that he didn't sense the same level of professionalism, maybe, and his ideas of professionalism, wearing a skirt and wearing high heels. Or maybe there was something else at play. But I would say the moral of that story, because the victim never knew what led to that lower number, probably didn't know it was a lower number in comparison to other employees. And I don't think the perpetrator knew that he was exercising some kind of a bias. But the moral of the story is when somebody says, I just don't feel the same, or that person doesn't look the part, we need to delve into it and find out really what's going on there so that we can understand it and evaluate it and maybe exercise one of those teaching moments I keep talking about. Okay, here we have some online input. A seriously injured 22-year-old in Chicago Cook County venue turned down a significant offer to settle because, counsel, I have 9 blacks on my jury of 12. You're done and will regret not meeting my demand. Bad faith, punitive damages, etc. Complete defense verdict. Every single one of those jurors were hardworking, good people who wanted to do what was right and found that my driver was not the cause of the accident. Both plaintiff and their counsel let their bias take away a settlement that would have been best for his client. Example is an excellent one. It speaks for itself. Here's another piece of input from our webinar participants. I have a client accused of inappropriately touching another woman in a small town bar's restroom area. My client is black and the complaining witness is white. My client is from Kentucky. He is convinced race is motivating the criminal prosecution. It's too early to see how it will play out, but it has me wondering if I shouldn't move for a change of venue. I'm sure the client will ask about moving the trial away from the small town. But if we do, that will increase the expense and time needed for trial, not just in bringing the motion, but also for travel if we successfully change venue. Comments? There's a swirl of bias at play there. Okay, well, let's move on to the next problem. This is our last problem. And this deals with those teaching moments that I've been talking about. It's a group function to engage as a leader, promoting diversity and inclusion. So what we want to discuss is an organization that you're aware of that needs a leader. And then we need you to reflect on what the historic, salient, or preferred or important identity is of a leader in that group versus what the group really needs. And then the third piece of it is how you would go about communicating a new ethos or a new ethic or a new way of approaching leader selection in that group. And obviously you can tell that this taxes you to think about how you can affect change in a culture. Let's give you 5 minutes for this, and we'll resume about 5 minutes till 4.
Well, I really, I can't do that. That'll just create problems. I'll just say the signature. That's a good idea. So I guess if we're discussing, please go ahead. It sounds like, oh, and I'm going strictly off what I saw in the papers, that there was this pressure. I don't know the woman, but I mean, and I think it's a misused term to call it boys club because that's not really how gentlemen and boys, even they are. But there was a certain culture that developed. There's a fear. Like I said, part of it just was inappropriate. So that was the, and it didn't quite help the fact that there was a chain of people that went through that. In terms of changing a culture like that, it sounds like one of the things in your firm you've done is those people don't stay. And the people that act like that are going to be welcome in your firm, in your culture. So it sounds like, to my mind, but I don't know how you, I don't know what you do.
Ensuring they kind of buy into the solution and that they are willing to take the lead.
Maybe that would be part of the benefit party is in control. That's going to be part of the ethos of that chamber. This is who you are.
eventually come back to the people. People, don't put people in office that are this or that or whatever. So you almost have to communicate that to the voters and the state. Right. How you do that? Yes.
Welcome back, everybody. Okay, so organizations out there who need a leader, what did you discuss? Let's try our conference room first.
We discussed a few different types of organizations. The one that we touched on before was Hollywood and Harvey Weinstein and that example. And really, it's kind of the basic framework. You have to establish that, you set the policies in place, you establish that framework, and then you communicate and you train on that. And you make it clear what the expectations are. And really that has to start from the top. So kind of top down type of expectations. And, that group may have a historic identity of being able to make inappropriate jokes and sexually harass, but we're in a different culture now. And so really that has to be communicated and trained and expectations made clear.
Good observation. And we talked before about how the accountability of the moment is what's affected that change. How about the other group? What did you folks discuss?
Okay, we picked the judiciary as the organization, since this would be close to the presenter's heart. In terms of requesting funding from the Iowa legislature, seems like the last several years, Justice Katie, he's made a request for funding, and based on lack of funds or other reasons, the legislature doesn't come through necessarily with what's requested. You think of Justice Katie as a nonpartisan, completely ethical, a person and a judge, obviously capable to make the formal request for funding, but maybe there's a new leader needed to be a more like a seasoned advocate. Maybe he isn't the right person to be making the request. Maybe it's required by the rules and at the legislative level, but maybe there's another person that could be more persuasive. So
the salient identity of the leader for the judicial branch, assuming that the request doesn't have to be made in that State of the Judiciary address, you're saying that there's a quality or qualities out there that haven't been recognized as being important enough to introduce that voice.
Potentially, yeah. Yep.
And so it's a tougher question. How do you communicate that new ethic to the judicial branch? Or did you just think you did it? You need your microphone up there.
Oh, sorry. Communicating a new ethics, yeah. Well, the legislature, there's lobbyists for how many countless number of groups asking for funds and money from the state of Iowa. So why doesn't, and maybe it's happening, we don't know it, but why isn't the judiciary lobbying legislators.
With a hired lobbyist.
Yes.
A very interesting example. Well, we have some input from our online people, and here's one. Any organization that has tolerated, ignored, or encouraged a workplace environment that permits or invites harassment needs new leadership. Several examples in the media, including major news organizations, which need to ditch the boys club ethos and foster new cultures of respect and inclusion. I think that sort of plays into what our first group here in the conference room was talking about with the Hollywood example and the media example. Here's another comment. I am the victor in a lot of situations which involve a mistake or wrong action on my part. I'm a young, attractive white woman, and people generally respond to me with less harshness or more belief in my sincerity than they might to a man, a person of color, or even an older person. So there's a different perspective about a victor. And I know we just headed to the printer to get some final input. Emily Chaffa, do you want to come up and deliver the identity codes for today's program while we're waiting on that last printed piece to come?
Yes. Thanks to all of you who've attended the entire 3 hours. So now one of your rewards, in addition to the, in my totally biased, overtly biased opinion, the excellent information you've received, I'll now provide you with the activity IDs. So if you are participating via the live webinar, the activity ID is 279073. Again, the webinar activity ID is 279073. For those of us attending the Ethics CLE in person, the activity ID is 279074. And this has been approved by 3 hours of ethics CLE. Again, the in-person activity ID 279074. And I'll also use my temporary platform to plug the Diversity and Inclusiveness Committee. We're always looking for more members, and we are also, and probably more importantly, looking for suggestions for other CLE programs that you might be interested in hearing, attending, perhaps presenting. So I'm pretty easy to find. So please contact me with any suggestions you have for future CLE programs that the Diversity Inclusiveness Committee can sponsor. Thank you.
Thank you, Emily. And in tribute to our online participants, we had some more comments come in that talked about the importance of communication within the group and how if we skip that step of communicating within a group, the need for new identities of leaders, new salient markers of leadership to be identified, then we necessarily exclude people from those personal and professional enrichment opportunities. So with that, I echo Emily Chaffa's thank you to you all for your attention and active participation here today. Have a good evening.